Turn your mic on.
The October 2023 TCOLE Commission meeting is now in session. I'd like to ask everyone to please rise for the presentation of colors by the Nueces County Sheriff's Office. I'd like to also ask that you remain standing through the invocation.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you, Commissioner Burris, for leading us in the pledge. I'd now like to ask Lieutenant Chuck Freeman, the chaplain of the Corpus Christi Police Department, to come forward for the invocation.
Hear me back there. Let's go to the Lord in prayer. Almighty God, this afternoon we ask for your humble blessing on each and every person here that represents the state of Texas in law enforcement. Lord God, as we sit here, we need to understand, Lord, that it's our duty as law enforcement to protect this great state. And Lord God, when we have you on our side, we have nothing to worry. So Lord God, we just thank you for the blessings that you pour upon us. And Lord God, we just ask for sheltering today on this roof. In Jesus' name we pray. Amen.
Amen.
You may be seated. Thank you, Chaplain Freeman. We appreciate it very much. Also like to recognize the individual members of the Nueces County Sheriff's Office, Lieutenant Joshua Warner, and Deputies Ernie Magana, Randall High, and David Alaniz. We appreciate it very much. Let's give them a round of applause, please. Well, good afternoon. It's wonderful to see so many of you here today. I'm Kim Lameau. I have the honor of serving as the Chief of Police at the University of Texas at Arlington, and also as the presiding officer for the Texas Commission on Law Enforcement. I'm also going to ask each of our commissioners to do a brief introduction of themselves with their name and their position and the city or county that you are from. Sheriff, let's begin with you.
Sheriff Mike Griffiths. Sheriff Mike Griffiths, Ector County. Almost 35 years in law enforcement, my 7th year as sheriff.
Martina Lamont Dixon, Houston, Texas, and I serve on the Humble ISD School Board.
Ron Hood, Hayes County Constable, Hayes County, Texas.
Jason Hester, Assistant Chief, Texas DPS.
Good afternoon. John Beecham, Interim Executive Director and General Counsel for the agency.
Patricia Burris, Dallas, Texas, a former prosecutor.
Mario Liscano, Administrator, Corporate Affairs for DHR Health, Hidalgo County.
Jana Atkins, Criminal Justice Manager, Training Coordinator for the West Central Texas Regional Law Enforcement Academy in Abilene, Taylor County, Texas.
Well, thank you very much for those introductions. On behalf of the TCOLE staff and my fellow commissioners, I'd like to welcome you to Corpus Christi. I'd like to welcome you to the 2023 TCOLE Conference and to the October 2023 Commission meeting. So we would like to thank the City of Corpus Christi for their amazing hospitality, to the American Bank Center for this wonderful facility, the Nueces County Sheriff's Office, and the Corpus Christi Police Department for their support and hospitality. Let's give all of them a round of applause, please. And the next group of people that I'd like to recognize, we would not be here without their hard work. I'd like to express a special thanks on behalf of all of the commissioners and all of us here attending the conference to the TCOLE staff for making this conference happen. For those of you that don't know, they have spent the last year preparing for this conference. We appreciate all of you that were here last year that provided us with feedback and suggestions, and they have spent the past year analyzing that, and they had some suggestions and ideas of their own, and they have spent the last year meeting and organizing to implement many, many changes for this year, and I have no doubt that because of their hard work and their dedication, that we are going to enjoy the biggest and the best TCOLE conference that we have had. So you will enjoy the week. We have a lot of information to pass on to you. I think some of the classes are exciting. We have some great presenters. Hopefully you'll make some new friends and lots of connections and partnerships throughout the week, and take back a lot of information to your departments. So I'd like to, at this point in time, to ask all of the TCOLE staff if you will please stand so that we can give you a round of applause. Come on, come on. You guys are absolutely amazing. For our audience, just a quick show of hands. How many of you are attending your first TCOLE conference? Wow. That's quite a few of you. So I think you're in, like I said, for an exciting week, a good week. And we look forward to the feedback that you'll provide us for this week. We have a great deal of information to cover in the TCOLE meeting today. You'll find that the TCOLE staff has been very busy throughout the year, but also since we met last in August, under the wonderful leadership of Interim Executive Director John Beecham. They have been working hard to onboard some new positions that we were fortunate to receive funding for in the last legislative session. So we're onboarding some additional people. That's going to allow us to provide better service, enhanced services, even some new services. So we have a lot going on that you will hear about today during the meeting. We also have some changes that are taking place as a result of the Sunset Commission review, and you'll learn a lot about that today. And we also, as we all know, have a lot of changes as a result of the recent legislative session that will impact many, if not most or all of us in the room. So at this point, again, welcome. Please let us know if there's anything that we can do. If you have any questions, please feel free to stop any of us. If we don't know the answer, we'll find someone that does. And we want to make sure that you have a good week and a successful week and that we meet your expectations for this week. So at this point, I am going to turn it over to John Beecham here, and he is going to lead us in the reports from staff. John?
Thank you, Madam Chair. I think you hit it right on the head when you talked about you talked about the changes that have occurred since last time we were in Corpus Christi. It's obvious by the physical settings, whether it be enlarged exhibitor area in the lower floor of the ABC, whether it be we're having a commission meeting here in the Selena Ballroom, the upward trend for attendees, the upward trend for a number of exhibitors, not only in the physical and numerical sense, but it also represents changes with both the profession in progress and an agency in progress. And I think everything that Chief Lameau talked about, whether it be the Sunset Bill, whether it be new staff that TCOLE has hired as a result of that, as we do the advisory committees, as we do Target 100 initiative, which we announced first here last year in the Garrett Ballroom, and everything that goes along with the changes in both the profession and the agency as a result of the sunset and the latest legislative session and everything that goes along with it. You'll be hearing about it during the course of the day, during this commission meeting, and you'll also be hearing more about it throughout the week. And Madam Chair, I'll turn it back over to you for a roll call if you want to do that.
Yes, Ms. Flout, would you please do roll call?
Commissioner Lameau.
Here.
Commissioner Hester.
Here.
Commissioner Burris.
Present.
Commissioner Hood.
Here.
Commissioner Adkins.
Here.
Commissioner Griffiths.
Here.
Commissioner Lascano.
Present.
Commissioner Lamont Dixon.
Here.
Thank you.
Sarah, we're going to continue on with agenda item number 3, and then I'll go back to 2.
Thank you, Madam Chair. Thank you, Sarah. And from the agency side, as we go through these changes and implementing these changes, one example, phase 1 of our rule implementations in response to Sunset you'll see today is Chief Lameau referred to earlier, the TCOLE staff. What I'll do is I'll introduce the executive staff that's here in the orchestra pit, and I think I know where they're at down there because it's the dramatic lighting in here. But we have Major TJ Vineyard, who's in charge of the Enforcement Division. We have Director Jessica Capraro, IT. We have Director Gretchen Grigsby, Government Relations. Director Colin Grissom, Credentialing and Education Services. and Director Brian Roth, Chief Financial Officer of the agency. Also, we have our newest hire, Assistant General Counsel Aaron Heath, and along with them in the rounding out the orchestra pit is Iris Martinez, Sarah Flott, and Alyssa Tabola. Thank you all. And what I'll do now is I'll turn it over to Director Capraro, and we'll have the IT and Information Technology report.
Good afternoon, Commissioners. Last time we met in August, we were approaching the end of the training unit for 2023, and I promised you the final numbers. So before I get there, though, I want to kind of take the audience down our Target 100 journey just a little bit. So we started off in March with the launch of a new application, or a new feature on our My TCOLE account called My Compliance. That lets all license holders log into their My TCOLE portal and see exactly what they need for their training requirements, specifically which courses they need and exactly how many hours they still have remaining to become compliant with their training requirements. With that, we started sending out notifications. We've always historically sent letters to departments and then expected departments to distribute that information to their officers and telecommunicators. However, this year we started sending out emails to the individual license holders themselves, and we got really great results. In March, we started with about 2,000 individual license holders that still needed training before the deadline. By the time we got to the end of August, we had just under 1,000 total license holders. And then and then today, now that we are at, all the rosters have come in, all the waivers have been processed, our final number is 14. That's it, 14. In all the telecommunicators and all the peace officers across the state. That's pretty powerful. That really speaks to the work that everyone has done, not just TCOLE, but all the training coordinators in the audience that have distributed our information, and all the license holders that have taken their training. Everyone is moving in the right direction together, and we've set that bar. We've done a really great job, and going into the next training unit, now that we're in 2025, we've got to keep that bar, and it's going to be more complicated. So if you'd like to know more about how you can help us achieve Target 100 in the next training unit, we do have a session tomorrow afternoon at 4 o'clock with credentialing supervisor Lisa Landry and myself.
Jessica, for the audience, can you or one of the other staff members provide a little bit of a comparison to past years?
Yes, actually, I'm trying to get that slide up right now, but it's not working.
And let me just echo what Jessica said. It takes all of us to make that happen, so thanks to each one of you in this room that's a license holder. Thank you for those of you that are running academies at your agencies for making this happen. If you're an administrator, thank you for making a commitment that your agency be 100%, because that's what Target 100 is about.
Yeah, the chart up on the screen right now shows how this training unit compared to the last comparable training unit, which was 2019. That was another 2-year unit. So you can see it starts in March, where we had about 23,000 individuals still needing training we had about 19,000 individuals needing training. That's the yellow bar, as compared to 23, which is the blue bar from 2019. And then you get down to the other end of the chart that shows the cases created in October. In 2019, we had 964 cases that were created, as compared to the 14 this year. All right, that's what I have for Target 100. The next thing is The IT team has been busy working on several different major projects, but one that's coming soon is our new website, which I have a picture of here. As soon as we have a good launch date, then we will be sending out a mass email to everybody letting you know that yes, this is our website, this is what it looks like. The URL should not be changing, but we're excited to launch it. Do y'all have any questions for me?
Questions or comments?
I have just a comment. Since I don't think you got the response from the commission that is merited, in my opinion. 14 new cases as of October is incredible. In my book, reaching 99%, 99 point whatever it was, 8% and 99.7% is 100% by rounding figures as I understand them to be. And so congratulations again to the staff, TJ, everyone on doing that work, and of course all of you out there that participated in getting all of your law enforcement individuals trained up in time. That's amazing. While we are up here to do enforcement, we don't want to do that. That's the bad part of the job. We don't like doing that. We'd much rather hear these great kinds of initiatives and work going on. So thank you all. For me, it's a round of applause to you all.
Any other comments or questions? John?
Major Vineyard, why don't you do the enforcement report, please?
Good afternoon, Commissioners. Before my report, going along with the Target 100, most of you know, as we approach the deadline, some of the larger agencies were asking for reports. They weren't always able to access it themselves. So Jessica's team started running the largest agencies, sending me those reports, and every week I would send them to the largest agencies. Of the 10 largest agencies in the state, 9 of those got to 100% compliance, which is a huge accomplishment, especially considering that some of them had extraordinarily high numbers in the past. And I wanted to recognize some of those people from those 9 agencies that I talk to almost every week, because I know the amount of time they invested. And I'm proud not only of the work that they did, but that they've adopted that as the new standard, that almost all of them have laid plans to be that successful in 2025. Lieutenant Kelly Wilkinson with Department of Public Safety, Officer Shannon Barker with Houston Police Department, Cindy Circle with Dallas Police Department, Lieutenant George Gonzalez and Captain Kimberly Smith with Harris County Sheriff's Office, Captain Sean Conjura and Officer Renee Lamond with Fort Worth Police Department, Lieutenant Manny Ramirez with Austin Police Department, Lieutenant Jason Johnson with El Paso Police Department, Captain Jessica Motane with Bexar County Sheriff's Office, and Lieutenant Johnny McGee and Sergeant Michael Chitty with Arlington Police Department. All of those agencies spent a lot of time and have adopted new plans, and I think that they will all be able to maintain that going forward. My report in your notebook includes the regular numbers. I have the non-compliance numbers at the top, which Jessica talked about. At least half of those people that are non-compliant have already completed their training and have been issued reprimands. So I suspect in the end we may have 3 or 4 suspensions as a result of training non-compliance. An update on RAPBAC. If you look at the numbers, we're down slightly for the total number of subscriptions and the total number of licensees. This is because of the number of officers who went inactive, right? We have a large group of officers who were not appointed, who did not do the training, their license goes inactive, and then they're removed from the database. So that's the change in the numbers. There's not a substantial increase in subscriptions. Most of the time on RAPBAC was spent. If you remember at the last meeting, we talked about having added thousands of records from a shared effort with DPS. As a result of that, we had more than 200 hits on licensee arrested and not been reported, so we've opened E1 cases and are in the process of generating those reports and tracking those cases rather than entering new people into the database. We've already started planning for 2025 training compliance. We have established relationships with some of those large agencies. We'll now focus on some of the smaller agencies, especially those that up close to the deadline had to work and do a lot of work educating them. Jessica and I have been talking about ways to increase the TCOLE usage and people who have accounts. So that was certainly something that we saw at the end when we sent the second and third emails directly to licensees, is that we didn't get calls, that people logged in, they were able to use TCOLE to determine what they were missing, and they were able to do the training on their own. So we still have a substantial group of licensees who do not have a TCOLE account, and we're going to find ways to encourage them to set up accounts and become self-sufficient so they can identify their training needs on their own. We're going to take efforts to encourage early adoption of 3188. That was another surprising thing to me, is how many people waited till the end of 2 years to take a legislative update for laws that they've been enforcing for the last 2 years. So we want to make a concerted effort to encourage people to take that earlier in the training period. And then our biggest concern, of course, is the 16 hours of active shooter training, and that medium and large size agencies in particular cannot wait till the end of the training cycle and expect to be able to complete that, since it's in-person training. So we're discussing ways to create tracking so that we can at least take those agencies, look at the total number of alert hours the agency would need, how far we are through the cycle, and whether they are, if we're 25% of the way, have they completed at least 25% of the training hours that would be needed. So it's not an exact tool, but it will allow us to identify the agencies that are lagging or could get caught at the end and encourage them and find ways to get them caught up. We've also discussed looking at the core classes that are required for basic officers and where those deficiencies are, and creating hotspot maps that we could provide to training providers so that we could make sure some of those classes like crisis intervention, if it's not available immediately, that training providers would know where the needs are and could provide those courses in the areas where they're needed most. And then the last thing is, we're still working with agencies. There are several of the large agencies that are adopting plans to help advance license proficiency. So in the past, even some agencies that have pay differential for higher proficiency certificates have found that officers don't do that. So what we're helping them do is evaluate whether the training load to help someone advance their certificate is less than the training that would be required to maintain the basic certificate over time. And so more and more agencies are adopting plans to do that. That's part of what Jessica and Lisa are going to talk about in their presentation tomorrow. And then my last update for you is on the case management system that we have adopted. We've been working with the vendor. We expect to go live with that in mid-November. Part of our push to implement it earlier was the anticipation of the non-compliance cases, but because we only had 14, we didn't need a computerized record management system to go up right away. So instead, we're customizing the system to better meet our needs.
Madam Chair, I'll go ahead.
Yeah, I'm sorry. To go ahead and clarify for the chief administrators that are here in the room, the 16 hours includes all peace officers, including agency heads. So TJ, how, agency heads, or most agency heads are mandated to attend the LEMIT training. Do we know how that's going to look? Obviously, LEMIT doesn't have the capacity to offer hands-on training. Do we know yet how that's going to look?
I think I'll defer to Cullen on that one.
Chief, in working with LEMIT and the Chiefs Association, police chiefs are mandated training through LEMIT. Working with Alert, the LEMIT staff, Alert is delivering 8 hours of training within the Chiefs Continuing Education module in this unit, and we foresee that going forward. So chiefs would come out of that with 8 hours credit towards it, and they would need to pick up the remainder of the 8 hours outside that training.
Thank you. Colin, I just want to clarify, because TJ said it and now we're sitting here talking about it. So the 16 hours is not mandated to be hands-on, not all of it.
There's not a specific mandate in the statute that requires face-to-face or.
Okay. So on the list of everything that came out of all the approved courses on the technical assistance bulletin, Not all of those classes are, some of those are online or a classroom-only portion.
Correct. Some of those are online courses, and we're negotiating real-time with Alert. Alert actually has some plans to build some other offerings to expand that. So we anticipate the number of classes that we look for to be in compliance with the 16 hours to actually expand. So there'll be more options to arrive at the 16 hours.
And I'm assuming y'all will update that technical assistance bulletin as those classes come online and push that out, right?
Yes, sir, we will. And also on the portion of the web page where we have the listing of requirements for the unit. And ultimately, that will be figured into the My Compliance query that individuals will be able to do on their My TCOLE account. So they should be able to track real time where they are for that as well as the other training requirements.
Okay. I just want to make sure that we're clear, because when we say in person, then everybody here thinks, okay, I've got to go through the level 1 every 2 years or whatever it is, and that's not the case, right? So if you're a small agency and you can't afford to have everybody going through that course at all the time, or you're a large agency like mine, it would take us a long time to get nearly 5,000 people through a 16-hour in-person for that time frame. It just needs to be 16 hours on that approved list that you guys sent out. Is that correct?
Yes, sir.
Okay. I just want to clarify that for everybody that's here, because otherwise we'll all get lots of questions after this is over with. Thank you.
That's a very important point. I don't think that you can take all 16 hours online right now, and I just want to make sure that people are planning for both contingencies, that there's not just the assumption they can do all their hours online in August of 2025. And I think that's what most of them are looking for, is how they're going to split that up and how they're going to accomplish that training goal as they add.
Which is perfectly fine. I just want to make sure that it's clear, because when we say online hours, or excuse me, when we say in person, the perception is that everything has to be in person, and it doesn't. You can do the mix. An agency may do an 8 and 8 or a 6 and whatever the number would be, as long as you get the 16 hours. That's what the key is. I have another question, if that's okay. Major, on the E1 notifications, you were talking about the RATBAC enrollments. Did I hear you correctly and say there were 2,000 that came back that you didn't have E1s on? Was that did I mishear you?
More than 200, I believe.
200?
Yes, sir.
Okay. And so are you opening up enforcement cases on those 200?
Yes, sir. So we track those through disposition. Some of those we will get reports on. Some of those people may not be appointed right now. There could be various reasons, but that's what they had to do, was go through all those hits. You're familiar with some of them preceded their appointment, some of them were during the academy, but some were post-appointment, so we had to sort through all those open enforcement cases on those who have an active license and it was within a period that would have affected their license, and then track those through disposition.
But those were convictions, those weren't just the hits, because that's the two. When you get the RATBAC hit, it may or may not be, it may just be the arrest with no conviction. But I guess you're still having to track that.
Exactly. So if they got arrested for DWI last year and they're currently appointed as a jailer, but it was not reported to us, we need to track that through disposition.
Okay. And just for everyone else, so now that you guys are getting notified when a licensee gets arrested, it's also imperative for the arresting agency and the licensing agency to both submit the E1 to TCOLE.
Right. 3 people should report within 30 days of arrest. The licensee themselves, the agency that they're appointed with, and the agency that made the arrest. And even if they're not appointed, they should report the arrest because it could impact their license status.
Yeah, but there's not a lot of licensees submitting that paperwork.
Well, we'll get the hit through RATBAC, and what will happen once we have the new records management system updated is we'll get a RATBAC hit, we'll enter a report, we'll set an alert for 30 days, and if we have not received a notification within 30 days, I would expect that we will start issuing reprimands to licensees who have not reported it and warning letters to the agencies they're appointed with. In some cases, we have found that the appointing agency was not aware that the licensee was arrested, and this gives us a mechanism to notify them 30 days out from the arrest. And then if there's evidence that the arresting agency was aware and took no action, then we would also notify that agency. So in some cases, the arresting agency is not aware. They have no idea the person is a licensee licensee, but in some cases it appears in the offense report or the arrest affidavit, and then they should expect enforcement action if that's the case.
Okay, and that's where I was going by my line of questioning, was what's going to happen in the future. And so just make sure everybody heard that. You guys are going to be looking at that, and if there's not the adequate reporting, then there is going to be an investigation and possible reprimands or whatever enforcement action that's required.
And in particular, our primary concern there is that there are some licensees who get arrested and have entered a point of crisis in their life, and there's a subsequent arrest. So if we notify them, execute that reprimand at 30 days out, and there's a subsequent arrest, then they should expect more serious license action, especially if they fail to report the first arrest and subsequently get arrested and do not make a report.
Okay, I don't have any other questions, thank you.
I did have one thing that I left out that was really important I would like to add. So we had 4 positions from Sunset. We have hired 2 new investigators. Joe Nichols comes to us from the Montgomery County DA's office, and Kevin Kelso came to us from Shiner, Texas. He was the chief of police there. So they both started and are working with us. We're excited to have them with us. Both have extensive experience and extensive contacts in law enforcement. The 3rd investigator position, we have made an offer and is in the background process, and then we intend to fill the 4th admin assistant position as soon as we can, and that's part of what they will be doing, is helping with the tracking of these E1 cases and expanding what we're doing there.
Any other comments or questions?
Thank you, TJ. Madam Chair, we'd have Director Grissom give the credentialing, education, and field services report now.
Good afternoon, Commissioners. I think the report's in your binder, but I do want to point out some things that are especially relevant to the assembled group here today. The basic peace officer course has been updated and is posted and out for public comment. One of the things, we've already talked about the active shooter training. The same bill that instituted that in-service training requirement also required us to add the alert level 1, and it's very specific that it be the alert level 1 class to the basic peace officer course. And so that is one of the additions or updates to several of the sections that are statutory based, updates in missing persons, missing children, child death investigation. So there are several statutory drivers behind updates. And again, for those in the audience, it is out for public comment. We ask that you mark it up, make those recommendations that you have. And so we are seeking comment on that. We're about to post a new instructor resource guide on the trauma-informed approach to sexual assault investigations, working with several stakeholder groups. That course has been reduced in the amount of time it takes by some efficiencies in design from 24 to 16 hours. That is one of 2 courses that is an option that is required in this training unit if people have not taken it in a prior unit. So if you remember back to the last training unit, we didn't impose it as a mandate, but we recommended that either 470 or 4070 was the 2 course numbers be taken. So if people took it in the last unit, they do not need to recycle through it. And I want to be clear on that. We're not remandating a course if they took it in the last unit. If they did not take it in the last unit, it is a requirement for compliance in this unit that they have one, either the face-to-face or the online version. There's an online version on their My TCOLE account that's readily available for free, no tuition, to come in compliance with that mandate. The second mandate is one that you, the commission, recommended, and that's our Finding Wellness, Building a Healthier Life course, which is a mental health and wellness course for licensees. That's mandated for this training unit. It's available. It was launched September 1st on my TCOLE. As of September 28th, we've already had 3,852 enrollments with 2,598 completions. Commissioners, I would encourage you to get on and look at that course. It's one of the first ones we've built entirely in-house with our new instructional designers and staff, and I will say that I'm really, really proud of the product. And we're getting a lot of compliments on its design and flow and content from the field. So I'm extremely proud of the work that Rachel and the Education Services staff did in building that course. But again, just as a reminder for the assembled group, that is one of the mandates in this 2-year training unit. Education Services newsletter is up to 2,058 subscribers. I would recommend that those who are assembled for the conference, if you're not on that list, that is a monthly distribution that we do, what's coming out, curriculum, what's on the horizon. We request help from subject matter experts through that. So if you want to engage in what TCOLE's doing in the education end of the spectrum, please subscribe to that newsletter, and you can do so on the website. I've included the credentialing information that you normally see in your packet in terms of number of calls handled and processing. A recount of the training mandates. Commissioner Hester, you know, we've got, talking about the alert training mandate specifically, there's a list of, I think it's almost 12, and that list will expand as to when we query for compliance for that 16 hours of active shooter, it will look for an aggregate 16 hours across all those courses and any courses subsequently added. And so we will try and keep that updated as fast as that changes. But we are working with Alert and their staff as they identify, and they're building new things, and they have their own learning management system that they anticipate more deliveries in the online section for that. That's really all I have, unless you have questions.
Questions or comments?
I do just wanted to clarify for the training coordinators out here, the Finding Wellness, that curriculum is also on the website to where you can teach in-house without having to do online.
Yes, ma'am. There is an instructor resource guide should you want to build a local version of that training and deliver it face-to-face. It gives a training provider the option of regionalizing it with local resources, and whether it's an employee assistance program that the city or county has, that they could highlight that. So yes, that is available for a training provider to do in a face-to-face format. Okay. It's not mandated that they do my TCOLE, but they must have one or the other.
Okay, thank you.
Madam Chair. Calling on the, and this may be a topic we get in later in the agenda, but as far as teaching active shooter classes that are on that list, does everyone have to go through and be an Alert certified instructor from Alert only to do that?
Yes, sir. Because of the way the enabling statute was written, the curriculum that we give credit for the 16 hours must be an Alert product, and it must have come from Alert. Now, let me clarify, it doesn't have, the training delivery doesn't have to come from Alert employees. Some people mistake that. Alert uses what we would normally refer to as a hub and spoke model, where as the hub, they do a lot of train the trainer, instructor training. When Alert authorizes those instructors to deliver their end user courses, that counts towards this. So it doesn't, in other words, an officer doesn't have to take training from a full-time alert employee for it to count. If the sheriff sends his staff to alert, they get instructor certification, they're delivering the alert level 1, for instance, under that umbrella, that gets full faith and credit towards the 16 hours.
So from a compliance perspective, so how do we ensure, what keeps me, I have my advanced instructor license, what keeps me from just teaching the class and reporting under alert stuff? Like, how are you gonna, are y'all linking back to the instructor's name to alert for compliance?
We don't have a model in place to do that now. We have discussed with alert, looking at some of that. The part of it is no, I don't want to say honor system, but failing to teach from an alert credential would be an enforcement case where we define somebody doing that. That would be misrepresenting. Now, one thing I do get a lot of questions on, Commissioner, is people who have gone to either FLETC, a Federal Law Enforcement Training Center, or National Tactical Officers Association. There are other active shooter products, but because of the way the statute was written, it has to be alert. Those other certifications do not count, should not be reported under the alert training numbers. So that's also a very common question.
Yeah, so just so everyone's clear, that's not TCOLE's decision or the commission's decision, that's in statute. It was specifically written in statute. Okay.
Yes.
My next question has to do with the BPOC. You said it was posted out for public comment. Are we deleting any major learning objectives, or are we just adding?
Most of the changes were most of the non-active shooter changes were statutory driven changes in the penal code, for instance. Didn't add hours, really didn't change the objectives. There are some, what we've done is added 16 hours. So we're, come January, which I forgot to say, January 1, any class starting after January 1 will have to be on the new curriculum and inclusive of all the changes. But we are not wiping out any major objectives. There's not a big sea change within the curriculum. Most of it is just updates based on statutory change. The addition, quite simply, we're not rehashing what alert has in their manuals. We're adding a section that says go to alert and do alert level 1. That becomes the objective to meet that statutory change.
And all those changes in the penal code and everything else, appropriate relevant test questions tied to that learning objective are going to be pulled out and changed?
Yes, we've got a professional test manager working to make sure that if a change in curriculum impacts the database, the question database, that we retire those questions.
We have a professional, what did you say? Professional test manager?
Yeah. We have
contract?
No. We have a full-time employee who is a test manager.
Okay. Thank you.
And that's their job.
I don't have any other questions.
Thank you. Colin, just a quick question follow-up. In talking to Alert, are they prepared personnel-wise, trainers-wise? Have we been in contact with them so we know that a year from now we're going to, there's agencies out here now wanting to get this training quickly.
Yeah.
If they can't get to it because they don't have adequate personnel, that could be a problem down the road.
The last number I received from Alert, and this is like a May number, is they had 5,000 instructors certified just within the state of Texas to deliver specifically their level 1 training. Alert continues to certify new instructors. One of the things, kind of to build on what TJ said earlier, is we hope as we're looking at compliance that we can do some heat mapping and try and work with training providers when, if Central Panhandle, it seems to be people aren't complying, we're going to try and help focus training either through a regional provider, a COG Academy, or a lot of times the larger agencies have the staff and capacity to do it. Can they help their neighbor get into compliance? So we're hoping to drive compliance with some analysis of what we're seeing, and I think TJ kind of gave some insight into that. So Alert, I'm confident Alert has the capacity and they're ramping up constantly to do more. Alert has kits available to their forward deployed or their other delivery. The folks who've authorized to teach it can request a grant-funded kit to use if they don't own the equipment themselves. So Alert's doing yeoman's work to make this happen on their end. So I couldn't ask any more of them than what they're already doing. They've been a good partner.
Thank you.
And I have one question to follow back on what you said, just because of me as a training coordinator. So, and that was my question. I've got Alert instructors, but as far as if we do it in-house, the kits, the manuals, everything from that, you're saying that Alert's going to be prepared to, get, if we make a request to do an in-house training, is that something we're going to have access to, or am I going to have to produce the manuals, those types of things, is what I guess was my question.
Commissioner, I don't want to go out on a limb and speak for Alert, but they are here at the conference, and I can get you an answer on that.
Okay.
I think that is their intent, but I can't definitively say.
That was my question, and mainly because I know we've got a lot of training coordinators out here that were thinking, okay, I'm not getting the paid Alert instructors. I've got some that are instructors, so how do we get all the product to teach it? I mean, they can come in and teach at level 1, but if we don't have, the kits, and we don't have the manual that they have and all of that, that was my question. Yeah. So I appreciate, I'll get with you later. And
yeah, we found Alert to be very responsive. Okay. My response would be, please contact the Alert Center, and they're very customer-centric and they're solution-based. So okay. I think you'll get what you need out of them.
Okay, thank you.
What's their booth number? Are they giving away free stuff at the booth?
I don't have their booth number in front of me, but if somebody wants to find me, I can lead you over there by the hand.
Thank you, Colin. Madam Chair, Commissioners, at this time we'll have Director Grigsby present the Government Relations Report.
Good afternoon, Commissioners. So as you know, this has been quite a year for TCOLE, and the work continues, and we want to thank you for all of your support throughout this entire legislative process and the implementation following thereafter. One of the things that we'll be talking about later today, of course, is the advisory committees that were established through our legislative sunset bill. I think you will see represented that we will be talking about some very critical stakeholders throughout all of those advisory committees. Many of them are also here this week, either as presenters or at booths or both. And so we really want to thank all of the stakeholders and all of the advisory committee members for the work that they have already started and are going to continue to do. As you will hear, all of the advisory committees, each of the 3 had their first meeting the week of October 9th, and all of them have another meeting scheduled for the first week of November. So they are very quickly getting underway, and they understand what's expected of them and the timeline that they have to work with. And so I think they are all up to the task, and we look forward to continuing to work with them. In addition to those critical partners, I also want to echo, Alert has come up several times today. Commissioner Hood, you asked if we had been coordinating with them, and yes, going back to before the regular legislative session ended, we had been talking with them about options, what they needed, what we needed of them, to be able to best serve our regulated community, knowing what's going to be expected of them and the challenge that logistically can present in accomplishing. But I think all working together, we're going to make that happen. And the Target 100 effort that we've implemented will continue and grow from there. Obviously, sunset, again, is the biggest component of our legislative implementation, but other work continues. In addition to the sunset bill, several of those pieces of legislation that passed are going to result in rulemaking, and so once we get to the rulemaking portion of today's meeting, you'll be hearing about a few of those pieces of legislation. As you likely know, if you've been paying attention to the news, the third 30-day special session is currently underway, having started on October 9th. There aren't a ton of TCOLE specific legislation that's been filed. The only one in particular is the refile of the Law Enforcement Agency Accreditation Bill by Senator King. It is Senate Bill 23 from the third special session. It's very similar to Senate Bill 267 that was passed during the regular session but was vetoed pending the passage of property tax related legislation per the governor's veto statement. There have also been several border security related bills filed that may affect our regulated community but are not TCOLE specific at this time. My report will be short today, but I do want to close it up with a plug for our Law Enforcement Achievement Awards nominations. We know that there are many, many great works out there by our regulated community that are conducted every day, and we want to hear about them, and we want to recognize our licensees for them. So we will continue to accept nominations for those through January 15th. So for anybody listening, anybody here, please submit those nominations. We really do want to make this a ceremony that is worthy of the fantastic work that our agencies and our licensees do every day. That concludes my report today, unless you have any questions.
I don't have a question, I just have a remark. This morning at the legislative update, that I want to thank all the attendees that came in to hear everything that was going on. Something that was pointed out was the important work that our team did during the legislative session, and pointed out Ms. Gretchen. So I want to thank you for all your hard work and all the team. It's important that we keep up to date with what is occurring. Important part is that we're also working with a lot of different agencies. So I just wanted to make sure that we acknowledge your work and that we are grateful for everything you did in this last session.
Thank you very much, Commissioner, for making that comment. For those of you who didn't keep close track of the legislative session, the TCOLE staff just knocked it out of the park, I think, during the legislative session. They worked really closely with the Constables Association, the Sheriff's Association, the Chiefs Association, CLEAT, TMPA, and a variety of other stakeholders. So the partnerships and relationships, I think, that have been forged, again, under your leadership, John, was strongly reflected in this legislative session. And I think from a legislative standpoint, I know in years past, we have to make the comment, we're not all going to agree on everything. You know, each one of those groups at some point in some piece of legislation is going to have to agree to disagree. Everybody's not going to be for everything. But what I saw this legislative session was everyone working together to try to come up with a consensus of what everyone could work with, what everyone could live with. And I think the legislators, instead of hearing a lot of testimony against TCOLE or people being upset with TCOLE, I was totally blown away by all of those different groups at some point in one of the committee meetings, you know, testifying and talking about the good relationship that they have with TCOLE, and that's a direct reflection of the work that you all have done. You know, I think the bottom line is, for most of us, everybody wants the same outcome. Might not always agree on how to get there, but anyway, just great work on that. John.
Thank you, Madam Chair. Finally, for the director's report, we'll present Director Roth with the finance report. I believe we have a graphic for this one, don't we, Jessica?
Good afternoon, Commissioners. Thank you for the opportunity to provide an update on our agency financials. You have in your packet the normal financial report, including expenditures and revenue. Also included for your review and up on the screen is a draft template for our fiscal year 2024 internal operating budget. For those in the audience who may be watching a commission meeting for the first time, our current budget comes from several laws passed during the 88th legislative session, including House Bill 1 and Senate Bill 1445, our sunset bill. For our current financial landscape, we're now in our first quarter of the fiscal year. Our financial position remains robust with an increased funding for peer network, school marshal training, consolidated data center services, and other strategic investments from the legislature. With that in mind, I'd like to quickly highlight some of the tasks we've done recently and the projects we're working on. As mentioned earlier, we're making great strides in our HR operations. The agency is ramping up, and we're capitalizing on increasing resources to bring talent to the team and execute on our new responsibilities. We have successfully onboarded 4 new employees this current fiscal year, with an additional 16 job openings that we're actively seeking to fill. And furthermore, there are plans to post 8 more positions in the near future. Currently, for funding sources, we're currently not relying on any grants for our financial operations. As mentioned in our last commission meeting, our school marshal activities have been sustained through regular appropriations for fiscal years 2024 and 2025. And securing the stable funding for school marshal duties, we've been able to allocate resources for 2 dedicated full-time employees and multiple annual training sessions without necessitating external grants for these school marshal responsibilities. The strategic investment in school marshal training has doubled compared to last fiscal year. As well, the funding for peer network has now been increased to $1.2 million per year. In a bid to accommodate this and other expansion and responsibility, we procured additional office space within our current floor. Currently, we have secured additional resources for data center services, specifically the Texas Public-Private Cloud. In recognizing these growing demands, we've recently initiated the deployment of credentialing, legal enforcement, and IT resources to manage our new responsibilities effectively. Since our last meeting, we've been committed to enhancing our financial processes internally and externally. Our efforts included tasks such as border security reporting and other pertinent financial reporting, including our annual financial report, as well as a personnel record digitization project. Additionally, we have actively focused on the recruitment and training of new agency personnel. And finally, our current focus is on executing legislative changes, like you've heard before, for the incoming fiscal year. We're actively implementing this new legislation as well as spearheading projects to focus on process improvement, record retention, and optimal utilization of our space. And with that, I'd be happy to answer any questions you might have.
Brian, thank you for your report. For the benefit of the audience, can you give everyone a general overview of what our budget was prior to this last session? It's very different than what it is now, but can you please tell the audience how many total licensees, what our annual budget was prior to, or the biennium, do that breakdown with those responsibilities, and where we are now?
Our current fiscal year, we are at about 13.1 million all in. That includes the additional funding for Sunset, as well as the exceptional items and other items for House Bill 1. That compares to about 6 million last fiscal year, so it's gone up quite a bit. Let me see, I believe our FTEs were up 39% versus the previous fiscal year, so quite a bit of growth in lots of different areas of the agency.
And when you say 39%,
yes,
when we had a $6 million budget for 100,000 licensees, we had how many staff?
67.6.
Okay. And so now I would say 6 million to 13, we've more than doubled this budget after the last session, which is incredibly huge, obviously, for us. So that's another, wow, great job to staff for getting out there and really putting in the work, pressing flash at the Capitol, which early in Gretchen's report, it sounded, you all were talking like it's over. I mean, we are still in a session. So it's not over yet. You never know what strange curveball things can happen. The fact that we have anything in there at all right now is a testament to, you got to stay on top of it. But thank you, Brian, for that. These are really tiny numbers, and I'm not sure anyone can see that out there. So we've got them on our screens here, but thank you for fleshing that out.
Do any of the directors have any further comment or any input based on the discussion for the commissioners? That concludes the reports, Madam Chair.
I'll make a motion to accept the reports as presented.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes. I would like to go back up to agenda item number 2. Commissioners, we're going to do this in 2 separate motions because we're looking at approving the minutes of the August meeting as well as the September meeting. And in the event that there's any questions or issues, it's just cleaner that way. So do we have a motion regarding the August commission meeting?
I make a motion that we accept the August meeting minutes as written.
Okay, we have a motion. Do we have a
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes. Do we have a motion for the September meeting?
I'll make a motion that we accept the minutes for the September meeting.
We have a motion. Do we have a second?
Second.
Motion and a second. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes. Folks, we are going to take a 10-minute break. Now, to get credit for this session, you need to come back, because for those of you that were in the session this morning, we had a QR code at the end of the meeting that you scanned, and that gave you credit for the session. Let me also explain something else. You gave us feedback last year that you didn't really like standing in the lines. It took a long time to get through the lines. So Jessica and her team came up with this, utilizing technology, came up with this really innovative way to give folks credit. So we can see all the doorways from up here. If we end up having a lot of folks that slide in, that disappear and then slide back in towards the end, then I'm going to tell you right now that I'm going to make the recommendation that we go back to standing in line and scanning folks through, and that'll be mine, and I will own that. So please don't do that. We're going to take a 10-minute break. We will come back, finish up the meeting. We'll put the QR code on the screen, and everybody can get credit for it. So let's do the right thing.
You went up there now, Kim?
No.
I'm waiting.
2, if you'll please show us back in session. We are now going to move to agenda item number 4, which is to discuss and take action if necessary on the advisory committee recommendations, and I'm going to turn it over to John.
Thank you, Madam Chair. Commissioners, what we're going to do in the next few minutes is, one, do an overview of the advisory committees, both the chairs and vice chairs, or presiding officers and assistant presiding officers, the basic statutory charge of each one of those, and then in a few minutes we're going to run through a overview chart of the misconduct process, which is the charge of, at least part of the charge of the misconduct and personnel and pre-employment background investigation advisory committee. I think Director Grigsby had referred to this earlier as a result of SB 1445, the TCOLE sunset bill. TCOLE is charged with creating 3 advisory committees, putting them together 3 advisory committees, which then in turn will either formulate model policies for the entire state or a corresponding rule for the entire state as it relates to, as I stated earlier, law enforcement agency standards, fit for duty for licensees as it relates to medical and psychological evaluations, and misconduct and personnel files and pre-employment processes.
I have seen several of y'all here today that are members of the advisory committees. I'm going to ask you to stand right now because you are representing licensees in the profession as well as the public from across the state. Would you please stand so that we can recognize you? These folks are volunteering their time to do this, and this is incredibly important work.
Thank you, Madam Chair. And again, thank you all to all who are participating and volunteering your time on the advisory committees. As Gretchen said earlier, the initial in-person meetings were held the week of October 9th at headquarters in Austin. As also, to reiterate what she said earlier, the plan right now is they will be meeting again the week of November 9th, and all the proceedings will be videotaped, the live in-person one, and they'll be available on the website as they become available. So we hope you get a chance to watch those and watch these policies develop. Again, we've got the deadline to come up with the policies is March 1st of 2024. So you should be seeing roughly the way, at least the initial impression of the advisory committees, their plan is looking roughly a meeting a month or so until they have their work complete. Obviously, so far they've done the initial meeting, they've got very far, a lot of progress so far, a lot of cooperation, and a lot of good discussion about the overall policies of law enforcement in Texas. So we hope you either are able to watch those or maybe even participate. The more participation, the better. And again, we appreciate everyone who's on those and who's participating in the discussions. Okay, I'll start with the general statutory charge of the law enforcement agency standards. This particular advisory committee is the presiding officer is Sheriff Roy Boyd of Goliad County. The assistant presiding officer is Chief Jaime Ayala of the Edinburgh Police Department. The basic statutory charge under SB 1445 for the Law Enforcement Agency Standards Advisory Committee is to develop minimum standards with respect to the creation or continuing operation of a law enforcement agency based on the function, size, and jurisdiction of the agency. And I have the graphic behind me with all of the members of the advisory committees for your information. We'll have these on the website shortly as well. As I said earlier, the committee will submit a proposed rule. This is a proposed rule that will be produced from this committee, submitted to approval for the commission by March 1st of 2024. I'll give you an overview of the statutory considerations that the committee is operating under. They'll consider the components, the determining regarding the public benefit of creating an agency in the community, The sustainable funding sources for the agency, physical resources available to the officers, such as all standard firearms, less lethal force weapons, effective communications equipment, officer uniforms, and patrol vehicles and associated equipment. That's not an exhaustive list, but just an illustrative list. Let's also consider the physical facilities of the agency, including evidence rooms, a public area and dispatch areas. Importantly, the policies of the agencies. You'll see some adjustments in the law from what it was previously. As we were discussing earlier, the discussion regarding active shooter and barricaded subjects training and policies will be required under these provisions. That's the overview for the Law Enforcement Agency Standards Advisory Committee. The next advisory committee is the Examination of a Licensee Committee. The presiding officer is Constable Sean Kennington of Camp County. The assistant presiding officer is Chief Mike Harmon of the Cedar Park Police Department. The statutory authority for the Examination of a Licensee Committee is a model policy which prescribes standards and procedures for the medical and psychological examination of new licensees, existing licensees, or those who employing agency has reason to believe that a new examination is necessary. Again, March 1st, 2024 is the model policy deadlines to be subjected to the commission. Sorry. Oh yeah, thank you. I've seen who's paying attention to the slides up here. Thank you, Commissioner Burris. There we go. Those are the committee members right there. Thank you. The statutory outline basically is going to encapsulate policies and procedures. This is under 1701-167 under Senate Bill 1445. You'll go through the list there, the procedural deadlines, the due process requirements. Again, these are the things that the committee is working on and looking through to ensure that upon the refusal to subject to a fitness for duty exam, both medical or psychological, that those due process rights and procedural rights are ensured throughout. As a general observation, the process is confidential and all information related to it is confidential. As I know, there was a great deal of discussion that in the initial meeting. So again, we look forward to your participation and observation as this process moves forward. The third advisory committee is the misconduct investigation. There we go. It's the misconduct investigation and hiring procedures and personnel file advisory committee. The scope of this committee is to establish procedures applicable to a law enforcement agency investigating alleged misconduct by a license holder employed by the agency and hiring a license holder and regarding personnel files maintained with respect to a license holder. The presiding officer of this committee is Chief Stan Stanridge of the San Marcos Police Department, and the assistant presiding officer is Assistant Chief Jessica Anderson of the Houston Police Department. And what I'm going to do is show the graphic here. Turn around here. Not yet. Again, we're seeing who's awake here. Close your eyes. We're running about trying to get the information here for you. I'll walk you through it till we have something, a visual aid up here. There it is. Thank you. All right, I'm going to cut this off and grab the handheld mic, and everybody may want to duck up here. We may get some feedback. I doubt it, but just in case. Okay, you see the top red box there. I'm going to read, for the most part, this right here. Again, this is the misconduct investigations flow chart, and this encapsulates, in general, the new misconduct policy that will eventually cover every law enforcement agency in the state of Texas. So we'll start up here in the red box. An agency is required to initiate investigation into quote-unquote alleged misconduct of an officer employed by an agency at the time the agency becomes aware of the alleged misconduct and completes the investigation in a timely manner. Obviously, you'll see some words here, some phrases, timely manner, investigation, and things like that. Again, those are things that the advisory committee is working on, and there are specific agenda items for the next meeting of the advisory committee. Well, they'll hash these things out for further discussion. Again, your input and participation is welcome. What does misconduct mean under this bill? It means a violation of law, a violation of law enforcement agency policy, for which the agency may suspend, demote, or terminate a license holder's employment, or an allegation of untruthfulness against a license holder. So these are triggering events which would require an investigation. Again, this is information and these are phrases and terms that the committee is working through in order to determine the proper scope and the appropriate scope as it applies to all law enforcement agencies. Now again, just looking at this as a broad overview, after the agency due process is provided after the alleged misconduct is investigated, since you have whether it is sustained or not sustained, if the answer is yes, the allegations of misconduct are sustained, it will then go into the personnel file. Everyone familiar with civil service cities, nothing is going to change. The definition of personnel file and what goes in it is the same. Essentially, this 1701-4535, which is the sunset bill, that's simply providing what everyone else under civil service, it applies to everyone essentially now. It's essentially the same definition as under 143-089A. Again, personnel file, for civil service cities, it's not going to change with respect to what goes in there. Sustained allegations of misconduct. Non-civil service cities, you're going to have this requirement under 1701-4535. And again, these are things in the model policy that are going to be fleshed out further. What if that allegation of misconduct is not sustained? Well, again, civil service city, it's going to go in the G file. And we all know the G file, the difference between the A file and the G file is at least with respect to public disclosure in response to a Public Information Act request. The G file is not disclosable, but the A file is subject to disclosure. Again, for a civil service city, it's not going to change. If it's unsustained, it goes in the G file. Sustained goes in the A file. Now, what you're going to see under the sunset bill is going to create this type of information for everyone else under 1701-4535. So again, if it's unsustained, it goes in there and it can be claimed as protected. Again, these are issues that are going to be worked out as we go along. Ultimately, now this was not subject to disclosure, not subject to disclosure. This is with respect to the public, with respect to ultimately reporting instances and completed investigations of misconduct and reports of those completed investigation. It ultimately is going to end up in the TCOLE confidential database. Saying again, both sustained and unsustained reports will ultimately end up in the TCOLE confidential database for review by prospective employers and indicators and markings and records of completed investigations as a result of the misconduct process. Again, as far as criminal charges and administrative charges that for alleged misconduct, criminal charges will be filed in a timely manner after the investigation is complete. All other investigations, that summary report that I talked about a minute ago that needs to be submitted to TCOLE, it's in a timely manner or no later than 30 days after separation of the licensee if applicable. Again, timely manner, these are terms that are going to be, the policy discussions are going to be had with the advisory committees. I think one thing it's important to remember when you're talking about the alleged misconduct and the reports and the ultimate reports that have to be submitted to the confidential database, always keep in mind in the background that the F5 report, come March 1st, 2024, will no longer be applicable. The F5 report with the categories of honorable, general, and dishonorable will not be applicable to separations that occur on or after March 1st, 24. They're still effective until then, but that day the F5 is essentially, it will no longer be, it's a dead letter at that point. Any questions that the commissioners may have for this?
So is the F5R, how does that play in with this if after March?
I think that's one of those things as we go through with the advisory committee, Commissioner Hester. Obviously, for everything that occurs before then, I think that process still continues on because you still have to fall under the law as it is now. Moving forward, I think that's a good question, but I wouldn't see a reason for it to continue on for anything on or after March 1st, 2024. No further entries is what I should say, no new entries.
How do you get the old entries? Will staff still, will it still be there? So there'll still be a need for it for a while.
That's
right?
correct, absolutely. Yeah, those don't go away because they're there already, absolutely.
Right. Okay.
There would be just no new entries for separations on or after March 1st, 2024.
So, all right, good work, good, that committee's got a lot of work to do, a whole lot. Thank you. I don't have any questions.
Oh, I'm so sorry. We're going to move to agenda item number 5, which is to discuss and take action on the proposed amendments to existing TCOLE rules and the proposed new rules. John?
Thank you, Madam Chair, Commissioners. I know we talked earlier about implementing the Sunset Bill. Here's another facet of it, the first phase of rule implementation, both in response to the Sunset Bill and other legislation that passed during the 88th regular session. This is, you'll beginning to start to see these as we move forward, but certainly these are the ones that were highest priority and the ones that needed to be brought before you. Obviously, during the summer, we presented to you the proposed rule that was finally adopted regarding the advisory committees, the procedure rule for that. I think this goes along those lines as well. With that being said, we'll talk about proposed amendment number 1. This is the amendment to include all exam attempts instead of only first attempts for the purpose of passing rate calculation. While this is not in directly response to the Sunset Bill, I'll let Director Grissom, he's going to give you a little background, and I know this has been the product of some discussions that have occurred over some months.
Yes, Commissioners, if you'll recall, during the summer meetings, we had discussed in workshop moving with our at-risk measurement or metric. Currently, it's across first attempts on licensing exams as opposed to across all 3 attempts. The part of the impetus behind this change or recommended change is come from the field, both on the want-to-be licensee or the test takers. Reports of academies not supporting people as much if they fail the first attempt. It's because that's what academies were traditionally measured on, and some test takers were at least complaining to staff that if I fail the first attempt, the academy no longer wants to engage with me. Now that's certainly, I wouldn't say that's the norm, but that's part of it. And then from the academy side, we have people who are distressed because people they're training are not taking the first attempt seriously. They're just going to see what the beast looks like, if you will. They kind of take that first attempt as, you know, an opportunity to see the content of the exam. So what we're recommending, or the proposed rule, is that we measure For the purposes of putting a training provider at risk, this is part of the larger scheme of at-risk status for those people who offer licensing courses, that we measure their performance across all attempts, which in this case is 3 attempts per licensee, as opposed to only measuring on first attempt. To give you a little historical background, prior to 2002, we didn't measure attempts. And then there was, as a result of the sunset finding back in the 90s, the commission said we needed to start looking at the testing. And so we went through several iterations. It got more and more complex. It was first attempts 1 year, all attempts across 3 years, and there was a formula. It was simplified ultimately to 80% across first attempts and a 3-year measurement. And this rule would take it across all attempts on the same 3-year measurement. Still maintaining 80% as the target pass rate, but we're measuring all attempts.
Commissioners, any questions or comments?
Well, I'm one of the newer commissioners, so I'm going to ask either one of my esteemed colleagues that's in law enforcement, or Cullen, if you can explain a little bit more deeper what that meant. When you said, so in the past, we were only measuring the first attempt. So a person, in essence, can take the exam 3 times. There are 3 opportunities in a 3-year period. So is that what you're saying? I just wanted clarification.
If I may, Commissioner, when somebody passes a state licensing course across a regulated license, that individual gets 3 attempts at the state exam. If they fail to pass those 3 attempts in 180 days, so that's the performance period. They have 3 attempts at the exam in 180 days. Failure to pass on all 3, they have to repeat the licensing course. There's no appeals, there's no process. It is a repeat of the police academy telecommunicator or jailer training is primarily what we're talking about. What we're really talking about in this rule is how we measure performance of academies, those training providers who provide licensing courses. There are multiple ways to get to what we term in the rules as at-risk status. Testing is only one performance metric. There can be complaints, there can be bad behavior by instructional staff, failure to follow TCOLE rules, failure to enforce their own rules that their advisory boards have adopted. All of those things are examples of something that would get us putting a training provider at risk until they either remedy that problem or we suspend or take action against that contract. It's actually a subcontract that we have with training providers. So what we're looking at is one of those ways to get classified at risk is what's traditionally referred to by our regulated communities, first try pass rate. We have measured academies on first try pass rate. And as I expressed before, there's some perception out in the field that that's not a valid metric, that we ought to be measuring across all 3 of those tries that a student gets to see whether or not the academy did their job in providing the training for the student. And so that's the change. I hope that's more explicit.
That clarifies. So I think when you said that really it's to benefit the training advisors in also supporting the officer in the process, whether it's the first attempt, second, or third. Right. Okay, thank you so much.
Yes, ma'am.
Madam Chair. Just also for clarification, we have some academies that teach the basic curriculum, and then we have other academies that go above and beyond. So like at my agency, we're roughly around between 1,100 and 1,200 hours. So it's nearly double of what we give to those recruits that we have. And so we go above and beyond that. And so sometimes if you look at pass rates across academies, it can be very misleading on that 80%. And so I think this, and I've been beating this drum nearly every meeting that we have and asking Colin in order to make sure that it's, to me, is more fair and consistent across those that teach just to the basic and those that teach above and beyond, that everybody kind of is on the same playing field from my perspective. Thank you, Madam Chair.
I love the rule change. I think it's going to help those couple of academies that have had some issues recently and historically. But I do want to kind of just express that this isn't going to change numbers by like wide margins. This rule change is great. It's important. It'll bring those. It'll make it more fair, and I think, as you stated, it's a better representation of what's really going on, and it'll affect, but the numbers aren't really huge out there that it's going to affect.
Commissioner Burris, I think what you'll find is by measuring first try pass rate, I hate to use the word victimize, it's harder on academies that have smaller numbers. So if you look at it statistically, if I only graduate 6 people and one of them fails to pass on their first try, well, that's hard. If I'm passing 100, to use DPS as an example, if I pass 100 troopers out of a class and 1 or 2 don't pass on the first try, it's easy for them to maintain the 80%. But if I'm a small rural regional academy and I'm doing 6, 8, 10 people at a time, 2 failures and I'm below the mark. And so I think measuring across all those tries, I agree it's not going to be, people who are not doing their job well are still going to find themselves at risk, and we'll take action on that, but I think it's fair to all involved.
Any other questions or comments? Do we have a motion in regards to the proposed amendment number 1?
I make a motion to approve amendment number 1 for posting. I make a motion to approve proposed amendment number 1 for posting to the Texas Register.
Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion passes. John?
Thank you, Madam Chair. Commissioners, next for your consideration is proposed amendment number 2, which this incorporates the addition of Texas Occupations Code Section 1701, 3095, and changes to the same chapter 451 made by SB 252 in the 88th regular session, and Texas Occupations Code Section 1701, 310 made by House Bill 2183 in the 88th regular session. Director Grigsby, would you like to give us some more background on this proposed amendment?
Thank you. So the first component of this, as John said, did stem from Senate Bill 252, and this was in response to a lot of law enforcement agencies coming to the legislature saying we are having some recruiting challenges and we think this would be a reasonable way to open up the current restriction for U.S. citizenship to those who are already legal permanent residents, who have honorably served in the United States Armed Forces and have applied for U.S. citizenship to be able to enter a law enforcement academy. So that is the first component of that. The second component expands the restriction on temporary jailer licenses. And this was in response to feedback from many of the sheriffs. If you'll recall, the Sandra Bland Act, under the Sandra Bland Act, you could only get one-year temporary jailer license, and it could not be renewed. That was it. You had 1 year and you were done. And the sheriffs, again, have had many challenges, as I'm sure Sheriff Griffiths can speak to, in recruiting staff for their jails to adequately and safely staff those jails. And so House Bill 2183 was passed that would expand the jailer licenses that would be available. It's no longer restricted to just one and done. You can have the 1 year temporary, that is still the initial baseline. Then the sheriff can petition for a 6-month extension of that 1 year temporary license. And then a second 1 year temporary can be administered beyond that if they haven't exceeded 2 years. So basically, to sum it up, you have, if all the paperwork is filed, you have 2.5 years to be a temporary jailer. Then if you have not completed your basic jailer license at that point to become a full jailer, then you have to sit out for a year, and then you can come back and go through the same process again. This is regardless of whether those temporary jailer appointments are at the same or different sheriff's offices. So it is cumulative and can't just be, you can't go from one sheriff's office to another and go through the same process over and over. So it's a little bit complicated, but I'm happy to answer any questions on that.
Commissioners?
Yeah, this is another good one. I'm glad you guys worked on this, and here's another example of something that came out of session, out of having those lengthy conversations with the Sheriff's Association and the Chiefs Association, and all being together kind of in that pressure cooker in Austin over the regular session this year. But it really allowed for you all to get together, have these discussions with us, and work through, kind of when you're sitting there waiting for the next person to testify, or, when we were waiting to be next on the agenda in those committee meetings and all that, to really hash out a lot of these issues and try to make it work. So I'm very happy to see that all of those discussions has become fruitful, and we have a solution that everyone seems to be happy with. So thanks for your work. And I would make a motion to, if there's no further discussion, I'd make a motion to adopt proposed amendment number 2 as presented.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Aye. Any opposed, same sign. Motion carries. John?
Commissioners, for your consideration is proposed amendment number 3. This incorporates the addition of Occupations Code 1701-253 and 3525, those two sections made by Senate Bill 1852. Colin, please.
Yes, Commissioners, Senate Bill 1852 is the active shooter response training bill. It did amend 1701 as specified by John, amending both the continuing education requirements and then the requirements of the BPOC. So the change in this rule would implement those.
Questions or comments?
Madam Chair. Counselor, just as a matter of clarification, when we make these rule adjustments, I mean, we're mirroring what's in statute. So is it necessary in the rules? Do we feel? I mean, I just want to make sure everybody's, all right. So with that, I make a motion to approve proposed amendment number 3 for posting to the Texas Register.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes. John?
Thank you, Madam Chair. Commissioners, next for your consideration is a proposed new rule 22146, section 22146, active shooter training for schools. This was, incorporates the addition of Occupations Code 1701, section 2515, made by Senate Bill 999. Director Grissom?
Commissioners, Senate Bill 999 requires now, under 1701-2515, a certificate for both instructors or providers of active shooter training to peace officers, primarily for schools and institutions of higher education. It requires we, the commission, to identify both a certificate to be held by an individual who's going to provide that training and subsequently a training provider. So this rule would help us implement that requirement.
So I guess I'm not understanding. This is just for training in schools for school marshal? Is this for the SBL, the school marshal base, the SROs?
The statute, the bill requires an individual or legal entity may not provide active shooter training to peace officers, the students or employees at a public primary or secondary or institution of higher education unless they acquire the certificate.
Okay.
And so if you were, for instance, teaching alert to a sheriff's department, you would not need this.
Okay.
If you were teaching this to ISD police or a group of SROs intentionally, or even at the university level, you as a training provider and the individuals teaching it would need to acquire this certificate. It's kind of a narrow focused bill.
Okay. And I guess it was the title that kind of threw me, because it says active shooter training for schools. So that's what threw me, was that title. Reading that as a proficiency certificate.
And Commissioner Atkins, if there's a point of clarification that we can provide that would make that title a little bit more clear on what it applied to, we can certainly look at that during the public comment period.
Okay, and that was just mainly for me as a training. I was thinking, now I'm gonna have to, have my instructors have the proficiency, I have to do it every 2 years, and I have to do something, so that's what that did not, and I'm glad you clarified it, because now I understand. I was reading it as across the board, any training, so.
Madam Chair, in Commissioner Atkins, I want to reemphasize what Director Grigsby just said. We can change the title or amend it as more appropriate as we go through the process. So again, this is the first reading. This is the proposed new rule. And again, certainly we can come back, and it's certainly not going to change the substance of the rule. We can certainly look into a more appropriate and more to the subject matter title for this particular rule.
I know that some out there would read that kind of like I did. And
Sure.
I have to have this now. So.
No, thank you.
Madam Chair. Colin, if we were, because I took it the same that Commissioner Atkins did, but if we expanded this to track everybody that's qualified to teach alert, then that fixes the problem we were talking about earlier about the honor system. Or no?
Good question, Commissioner.
I mean, not to put you on the spot in front of all these people, but.
Potentially, yes, sir. But I don't have enough to make a really informed decision.
Because we're limiting, as written though, the title is not the same as actually what 1701-2515 is saying. Because that's specifically to delivering to schools.
Correct.
And school district personnel. Yeah. Okay.
I mean, in proposing this rule, we were strictly trying to come into compliance with the constraints of 999. If we wanted to broaden the scope of it, we could come back with a different proposed rule or look at modification during that same period John spoke of.
Yeah, I'm just. Because it just seems like I have to have a certificate. If I'm a peace officer and I'm teaching to school district personnel, I have to have a certificate. But if I'm going to teach to my agency only, I don't have to have this certificate. But both ways, I'm going to have to be alert certified, right? So that's just where I'm going with that. And I think if we start changing with the 1701-2515, and we come back later to delete that, that's going to be a substantive change which will require reposting to the register.
Yeah, that's exactly right. I'm trying to think if there's a way that we could somehow propose this, but also give us some room to negotiate the question that you posed a few minutes ago. I think the way it's written now, I think it's as Cullen said, it's a little bit narrower. It's narrow in scope. Perhaps if we broadened it, that may, if we do need to change it, I don't necessarily know that would be advisable at this time, but I think at the very least, we'd give an opportunity to compare the situations that you were talking about and see if this resolves that. And if the worst case scenario is we have to repropose it, we repropose it, but at least we would have an opportunity. That's the purpose of the discussion today, is to make sure that we're not certainly in conflict with these rules and certainly not with statute, but we're covering all the scenarios we need to ensure everyone has the training they're supposed to.
I don't have any other questions, Madam Chair.
Do we have a motion?
I make a motion to accept the proposed rule as it's written. Yes.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes.
We'll see how that comment comes back. Public comment period for everyone in the audience.
It's part of the process, right?
Okay, we're going to move to agenda item number 6, which involves a request for a Class B waiver of TCOLE Rule 217.1, minimum standards for enrollment and initial licensure. John?
Thank you, Madam Chair. Next for your consideration, Commissioners, is the discussion and possible action on request for a Class B waiver under TCOLE Rule 217.1 regarding minimum standards for criminal disqualifications. This was submitted by the Robertson County Sheriff's Office. It was Sheriff Yazak on behalf of Justin Wilson. This is in regard to a February 2014 obstruction of a highway, a Class B misdemeanor. As the particular disposition was found as a result of an audit done by TCOLE FSAs during April of 2023. The applicant disclosed on the personal history statement this particular disposition. I believe it's 28 in your packets. As an additional note, the 10-year bar on Class B misdemeanor exclusions, I should say, for this particular licensee would conclude, in February of 2024. For your consideration.
Yes, if I could ask both Mr. Wilson and Sheriff, if you'll please state your name and then any comments that you have, please.
Okay, good afternoon. honorable commission members. My name is Gerald Yezik, and I'm sheriff in Robertson County, and this is Justin Wilson here with me. Thank y'all for having us here at your meeting. To tell you a little about myself, I'm a dual license member by the commission, master jailers, master peace officers. My peace officer's license bears the signature of Fred Toller on it, if that tells you how long I've been around. But being sheriff, as Sheriff Griffiths can attest, that's just my day, night, weekend, and holiday job. In my spare time, I'm in livestock and hay production, and in my community service, I sit on the board of directors with Scotty's House, which is a child advocacy center in the Brazos Valley, and I'm also on our local mental health authority board of directors, and I've done that over 20 years. They in turn appointed me to the Texas Council of Community Centers in Austin, which is the state board of the state association of the 39 LMHAs across Texas. And I'm also the chairman of that board. So over my career, I have received a number of accolades. I'm only going to mention one, and that's my most recent, is that I've recently been honored with the award of Texas Crime Stoppers, Judge Richard Carter Lifetime Award. It's very humbling to receive that award. It was bestowed to me at the conference earlier this month, and only 6 people in Texas have received that, and I'm the only peace officer in the group. But with that, we do appear before you today with this request for a Class B waiver on 217.1. Yes, Justin will be available in February, but I respectfully request that you please approve this waiver. I have one opening in my jail, and this would take care of that for us. It's not only important to us at the sheriff's office, but also Justin. He would like to have that job. We'd like to have him. And when his license was pulled, county commissioner immediately picked him up. So he's maintained his employment as a county employee. And on your information packets, there's information about him there. You'll see that he does have some status there in the county with us. You know, he's even a current member of our July term of our grand jury. So if you have any questions of me, I'd be happy to answer those. If you would like to hear from Justin, he stands here before you. Thank you.
Good afternoon. Justin Wilson. I was employed with the Sheriff's Office for approximately 2 years before my license was pulled. Yes, ma'am. Sorry. I was employed with the Sheriff's Office for approximately 2 years before my license was pulled. Like Sheriff said, one of the county commissioners picked me up almost immediately after that. I definitely don't have the credentials that the sheriff has, and the many accomplishments. I'm a member of the Masonic Lodge, and I have been since, I believe, 2012. I was on the volunteer fire department for a while, and I withdrew from the fire department just because my kids started getting up a little older and life got busy and I didn't have time to commit to it. But I would appreciate the opportunity to return back to the jail, and y'all take me in consideration for the waiver.
Madam Chair. Sheriff, so this came out during an audit, and looking at the packet, the applicant disclosed the stuff on here. So I think the one thing is it should have been readily apparent that he wasn't eligible for licensure to begin with. I'm assuming you've taken steps to rectify that in the agency process.
Yes, sir, we have.
Okay.
And the curveball in that process was the term conviction.
Okay, so, all right. That's what I was going to ask of that on with that, and so.
Yes, sir, Mr. Wilson was hired by my assistant jail administrator.
Okay.
Sheriff, could you go into a little more detail about what you've done to ensure that this mistake will not happen again in the future?
Implemented new policy on it.
Could you expand a little bit more upon that, please, sir?
Yes. All applicants will be screened in detail and in depth, and it'll also be a second and third set of eyes put upon it before a decision is rendered.
I'm assuming that maybe there's some training involved also, sir?
Yes, ma'am, that is correct.
I just have a couple comments to make. One, Sheriff, it's good to see you. We served on Texas Council about a decade ago, so I'm glad to see you're still doing that work, and congratulations on being the chair of the board.
Thank you, ma'am.
I just kind of wanted to wrap things up from my perspective. I thought something that was really important was that, Mr. Wilson, you were very honest throughout the application. So this wasn't a matter of you withholding something. In fact, you talked about the Class A offense, not the Class B offense of which you were convicted. And so I want to commend you on that. I think that carries a lot of weight. I know it carries a lot of weight during the investigation into this commission. So that was noted in the 100 or so pages of the packet that you all submitted, and I wanted to commend you on that. In addition to that, as you stated, the jail administrator took responsibility for the error, and I think that's something really to be commended as well. She stepped forward and said, this was my job, I messed up in this situation, and that speaks a lot to the department that you're running, Sheriff, that every person involved seems to step up, take responsibility when there's mistakes, because we're all human. We're all going to make mistakes from time to time. Sometimes things just slip by, and so I thought that spoke a lot to the character of your agency. And then lastly, for you to make the effort to come and do this when Mr. Wilson could wait 4 more months and just be eligible on his own. Again, one, it's important, I think, for us to help you fulfill the need that you clearly have to put him back in that position. It's definitely jailers, jails, it's something that we've been discussing this last year in depth. It's not really anything on our agenda here today, but I do want to let you know that as a commission, we've been having many discussions, and with our IT department and the staff, we've really been starting to drill down into those numbers and to figure out what can we do to help you all out. It's a safety issue, it's a health issue for the community, for the jailers, for the individuals in jail, for all the individuals that go in and out of the jails, whether it's health staff or the attorneys or whoever it is. So I just wanted to let you know, let everyone know that it's something we take very seriously, and we're looking at very closely to see how we can advocate better and try to fill the huge void that there is in staffing for those positions. So That's all I have to say, though. Thanks.
Okay, thank you, young lady. Good to see you again, too. And really, it works best for those we serve when we all work together. Thank you.
Okay, Mr. Wilson, I guess I have a question on, what have you done personally to prevent something like this from happening in the future? As far as your actions are concerned, I mean, a lot of times when people come and speak with us, there's a lot of remorse and they're explaining, where they were and where they are today. So I would just like a little bit more clarification on what that looks like going forward in your life.
It was definitely a mistake on my part. It's a mistake that I'm not going to make again. I mean, it's affected my job, possibly could have been a career. Over just, I guess, meeting up with someone that I haven't seen in a while and wound up getting in trouble. And I don't, like I said, I learned from my mistake by not taking that gamble anymore. And at the same time, I think, put my kid's life on hold per se. I mean, yeah, I'm still working right now, but I don't have any kind of medical insurance. If they get hurt, it's out of pocket. I've got to figure out what I'm going to do over a mistake I made being careless.
Thank you. And then I guess this will be a question for Cullen. I am trying to understand, so because we have had several of these over the past year, right? It's different situations, different scenarios. And a lot of times the applicant did disclose it on their application. And I understand like the ones that were, 15 years ago or what have you before things were automated. But one question I have is when a situation like this happens today, where someone actually discloses the information on their application and then it's found later through an audit on our behalf, is the agency that they're working for, are they tagged? Do we track that? Do we know that individual agencies have had 5 occurrences in this, way? I mean, where is, I guess, that information, and are we tracking that information?
Yes, ma'am. If it's subsequent to an audit that we perform, all of our audits are tracked over time, including deficiencies. So what we're looking for, if criminal history, it shows up as a deficiency over and over, where either they're misinterpreting the statute or they're failing to do it. If the genesis is in field services with an audit, and that gets tagged, then it would go over to TJ's group in enforcement, ultimately for an enforcement case. And what we're looking for long-term across any deficiency is patterns of behavior. We know mistakes get made. We try and treat them for what they are, but it's that pattern of behavior or laxity in process. And so most of our regulated community is doing they're doing their best to do their job most of the time. So we are looking for individual patterns. Does that answer your question?
Yes, and I understand, there is obviously an element of human error. I was just curious on, I think when you have an individual officer that does something, it's on their license, but the agency itself, is there any, responsibility taken when something like this happens? Is it tagged or marked that this agency had this situation?
Yes, ma'am.
Just and TJ might be wanting to chime in here, but as a result of the last session where we had authorization for RATBAC enrollment, this kind of stuff probably won't happen again, or will be caught a lot sooner on the appointment, or not, TJ, with that.
Yes, but you may be talking about two different things. I just want to make sure that you understand, right now, we can track how many times they've had audit deficiencies, but I don't know that we can pull that individual statistic about how many ineligible persons have been appointed with an agency. I think that's what you're getting to. With the new records management system, we will have individual title codes that will allow us to separate that. And more importantly, if a chief administrator travels from agency to agency, we would be able to see how many were attached to that particular chief administrator, because sometimes that follows the chief administrator rather than the agency. So we don't have that granular detail and data right now, but we will. We are moving that direction for that particular reason.
For that particular purpose.
And then,
Thank you.
and what Commissioner Hester is talking about is the second part of that, that we will be able to attach to every licensee and then show which agency they went to in that period of time and which chief administrator was attached. So we will start to build reports that will allow us to see if those are trends in a particular area or if they're single instances. And the last ones that we have heard here, I think where people were appointed when they were ineligible, that we were able to see that that agency went back and audited to make sure no other persons were appointed in the same manner.
Thank you. I have no other questions or comments.
I'll make a motion to grant the request for Class B waiver of TCOLE Rule 217.1 to Robertson County Sheriff's Office on behalf of Justin Wilson.
Okay, we have a motion and we have a second. Sarah, we're going to do an individual roll call, please, from the bottom up. If you will call each commissioner's name, please.
Commissioner, so sorry. Commissioner Griffiths,
Yes.
Commissioner Lamont Dixon,
Yes.
Commissioner Hood, Commissioner Hester,
Yes.
Commissioner Burris,
Yes.
Commissioner Lascano,
Yes.
Commissioner Atkins,
Yes.
Commissioner Lamo.
Yes.
Thank you.
Motion passes. Congratulations to you both, gentlemen, and we will trust, Sheriff, that your staff will receive the appropriate training that's needed so that this mistake doesn't happen again. So.
Yes, ma'am, and thank y'all.
Appreciate y'all's time.
Folks, I know we're going a little bit long here, but we're going to push through. We're going to push through this next section. So we're going to go to agenda item number 7, which is taking action on proceedings for revocation, suspension, and other disciplinary actions. John.
Commissioners, for your consideration, the first group of disciplinary actions for your review are the default revocation orders. These are actions that petitions for revocation were sent out based on either assault, family violence related, or directly involving the duties of a licensees for the following licensees: Dylan M. Hightower, default revocation recommended for assault by contact disposition; Jonathan Pena, disposition for official oppression, a Class A misdemeanor; Fernando Robledo, assault by contact on offense involving family violence. For your considerations, those licensees for revocation.
Counselor, just for clarification, we went to revocation orders first, is that correct?
That's correct.
Okay. Madam Chair, I make a motion that we accept the Executive Director's recommendation for the default revocation orders for Dylan Hightower, Jonathan Pena, and Fernando Robledo.
Second.
We have a motion in 2 seconds. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes.
Commissioners, for your consideration, thank you, Commissioner Hester, default suspension orders. We'll start. These were for petitions that were not responded to in a timely manner that were sent to the last known address of the following licensees for the specific offenses: Cairo Caballero, driving while intoxicated; recommended 10-year suspension. Annabelle Davia, driving while intoxicated, recommended 10-year suspension. Eddie Garcia Jr., unlawfully carrying a weapon, a Class A misdemeanor, recommended 10-year suspension. Christopher Hernandez, driving while intoxicated, recommended 10-year suspension. Ricardo E. Maldonado Jr., obstruction of a highway, a Class B misdemeanor, recommended 10-year suspension. David A. Trevino, driving while intoxicated, a recommended 10-year suspension. Those default suspension orders for your consideration, Commissioners.
Madam Chair, I make a motion that we accept the Executive Director's recommendation for the default suspension orders of Cairo Caballero, Annabelle Davila, Eddie Garcia Jr., Christopher Hernandez, Ricardo Maldonado Jr., and David A. Trevino.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes.
Commissioners, next for your consideration is agreed suspension waiver. This is where the licensee received a petition, signed the proposed waiver of a hearing on the back, and agreeing to the suspension term as pled in the petition. This particular for Justin Westbrook, Chief of the Commerce ISD Police Department, based on allegation of submission false or untruthful background confirmation forms to TCOLE, that these were conducted on 4 licensees. It was a recommended 90-day suspension. The agreed suspension waiver was signed and returned for your consideration, the agreed suspension waiver for Justin Westbrook.
Madam Chair, I make a motion that we accept the Executive Director's recommendation for an agreed suspension waiver for Justin Westbrook.
Second.
We have a motion and we have a second. All those in favor say aye. Aye. Any opposed? Same sign. Motion passes.
Commissioners, next for your consideration is the agreed suspension order for Kimberly Cabello. This was for the offense obstruction of a roadway or highway, a Class B misdemeanor. There was an informal conference before agency staff, a discussion and presentation of mitigating evidence to commission staff, which recommended to the interim executive director a suspension of 2 years, followed by a probated suspension of 8 years. For your consideration, the agreed suspension order of Kimberly Cabello.
Madam Chair, I make a motion that we accept the Executive Director's recommendation for agreed suspension order for Kimberly Cabello.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed? Same sign. Motion passes.
Commissioners, next for your consideration is the agreed suspension order of Carl A. Van Sluten for the submission of an F5 report to the Commission allowing an expired temporary licensee to stay employed. This was after a hearing at the State Office of Administrative Hearings, a previous recommendation, an amended petition from revocation to a 1-year suspension. A proposal from decision was issued in this case, which recommended a 90-day probated suspension. The terms were formally offered after further review of mitigating evidence and the proposal for decision. The Executive Director has considered and recommends the acceptance of an agreed order suspending respondent's license for 15 months, fully probated, for your consideration.
Madam Chair, make a motion that we accept the agreed order suspending the respondent's license for 15 months.
Second.
Thanks. And a second.
And that's a fully probated suspension on
Fully
that.
probated, yes.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed? Same sign. Motion passes.
Commissioners, for your consideration next is a proposal for decision which was issued by the State Office of Administrative Hearings based on the June 17th, 2020 disposition or conviction for assault causing bodily injury of a family member, a Class A misdemeanor for Reginald Thomas. The Executive Director determined that this was a misdemeanor offense involving family violence, filed an action seeking license revocation. The Office of the Attorney General filed a motion for summary disposition. The State Office of Administrative Hearings granted the motion and issued a proposal for decision finding that respondent had committed the offense involving family violence and recommends the revocation of respondent's peace officer license. The Executive Director recommends acceptance of the proposal for decision revoking respondent's license.
Madam Chair, I make a motion that we accept the proposal for decision, the proposal for decision revoking the respondent's license for Reginald Thomas. Yes, he's here.
Second.
Madam Chair, I would like to, for matter of procedure, withdraw my motion.
Is Mr. Thomas here? Is he present? Okay. Sir, would you come up to the mic? Sir, would you state your name and any comments that you might have for the commissioners?
Yes, ma'am. My name is Reginald Thomas. You said any comments?
Can you speak up, please?
Yes, ma'am. You said any. I didn't hear what you said.
Yes. Do you have any comments for the commissioners?
Yes, ma'am. Thank you, commissioners, for having me. I just would like to notate that it wasn't a conviction. It was just I was placed on deferred probation. I would like to also say that I had got notification of a hearing on August 13th, 15th, I want to say, and I got told it was canceled, so I wasn't even able to attend. But I just want to say that I did make a mistake of ignoring the red flags and being in an abusive relationship, which is the reason for the offense. I also want to say that I sat in jail an innocent man during COVID. So I took I'm not afraid to admit it, but I took a plea to get out of jail because I was sitting in jail an innocent man. So I took a plea for assault, family violence, misdemeanor, even though the facts of the case is that there was no assault committed. But I personally took a plea to get out of jail, and I don't think anybody in this room would sit in jail calm, innocent, knowing that sit in jail knowing that they were innocent. So yes, I took a plea to get out of jail because my sanity started messing with me. And during COVID, they wouldn't let nobody out. So that's just me. But I would like to thank you again for having me in front of y'all, and I really would like the pleasure of joining law enforcement again. Thank you.
John, let's start with you. Do you have any comments? And then I'll open up to the commissioners.
The only thing that I had to add, Madam Chair, is looking through the proposal for decision on page 2, respondent is a licensed peace officer in the state of Texas. These are the findings of fact. On February 4th, 2020, respondent physically assaulted the victim. These were the findings of fact by the State Office of Administrative Hearings, the impartial administrative law judge. At the time of the assault, the victim was respondent's girlfriend. As a result, the victim had called the police and reported respondent had kicked in the door to her apartment and strangled her. The arrest was for assault family house member impeding breath and circulation. Ultimately, there was a deferred adjudication, and keep in mind under TCOLE rules that a conviction or deferred adjudication, they're treated exactly the same for the purposes of license action. As a result, this was ultimately a Class A misdemeanor for assault family violence. It was placed on community for 2 years. As the proposal for decision states, those findings are pretty clear. There was it was assault to family violence, Class A, and as a result of that, the rules are very clear that is a required revocation once that finding has been made.
Commissioners, any comments or questions for counsel? Or Mr. Thomas?
I just have one comment to make. I want to thank the staff. I don't know why I'm being so laudatory today. It's not like me at all. But I appreciate having all of the backup information in here. I presumed that you did it because you believed you may be asked for backup information related to this. So I did appreciate having that in there. It allows the commission all of that information to go back and look at what the ALR judge said, look at what came from that SOA hearing, and look at all the pleadings. It was helpful should there be any questions by the commission and by the recommendation of the executive director. So I thank you for including that information. It did help shed light on it.
Thank you.
Do we have a motion?
Madam Chair, I make a motion that we accept the proposal for decision for Reginald Thomas.
Second.
We have a motion and a second. Sarah, let's go ahead and do an individual vote. Bottom up again, please.
Commissioner Griffiths? Commissioner Lamont Dixon?
Yes.
Commissioner Hood?
Yes.
Commissioner Hester?
Yes.
Commissioner Burris?
Yes.
Commissioner Lascano?
Yes.
Commissioner Atkins?
Yes.
Commissioner Lamo?
Yes. Mr. Thomas, I'm sorry, we will not be reversing the decision. The statute and the rule speak very clearly to what our duties and obligations are, but also speaks to the integrity of the profession. So we wish you the best of luck, sir, and do appreciate you coming and being here with us today, so thank you. John?
Commissioners, next for your consideration is a default dismissal/revocation order. This was a matter submitted to the State Office of Administrative Hearings regarding Eric Lerma regarding false or untruthful personal history statements for failure to disclose previous arrests, detention, and litigation, including those related to assault, family violence. That includes 2 prior arrests, 4 prior acts of charges, involving assault, family violence. As a result, a revocation action was sought against Eric D. Lerma for these untruthful or omissions on personal history statements. There was a request for a SOA hearing. There was a motion for summary disposition filed. There was a hearing set. The motion for summary disposition was denied. There was a scheduled hearing on the merits for August 1st, 2023. However, respondent did not appear. The State Office of Administrative Hearings issued a default dismissal order, which sent the case back here to the commission for disposition on a default basis. Essentially, you'll be considering whether or not to enter a default revocation order for failure to appear at this hearing. On this basis, the executive director recommends revocation of respondent's license as requested in the original petition on a default revocation basis for your consideration.
Madam Chair, I make a motion that we accept the executive director's recommendation of a default revocation order.
Second.
We have a motion and we have a second. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes. John?
Commissioners, as we introduced earlier, Assistant General Counsel Aaron Heath, we're going to welcome to the commission meeting family here. He's going to give you the for information only suspension and revocations.
Thank you. Good afternoon, Commissioners. I've met some of you already, but my name is Aaron Heath, and I'm an Assistant General Counsel in the Legal Division. As you heard in the Interim Executive Director's report, I'm relatively new to the agency, and I look forward to serving with you and getting to know you. Lastly, we have the information-only actions, which do not require any action on your part. There are 3 statutory suspensions. There are 5 statutory revocations, 1 term surrender, and 15 permanent surrenders for your consideration. Sorry, just for your information. Correct.
Okay, we have agenda item number 8, which is discuss and take action on the process, procedure, and qualifications related to the selection of the next executive director. I expect that we will have a decision forthcoming before the end of the month. So we'll move on to agenda item number 9, which is to receive public comment. I have a card here for Jimmy Jackson. Yes, sir. Would you please come to the mic and state your name? And please understand that any comment you make, the commissioners will not be taking action on any comments.
I'm not requesting any action, ma'am. I simply wanted to briefly come and I wanted to offer a thank you to Director Beecham and his staff for working. My name is Jimmy Jackson. I'm the Law Enforcement Chief Deputy for the Smith County Sheriff's Office in Tyler. And Director Beecham and his staff have worked with us to integrate a pilot program where we're introducing the detention officer curriculum into our Career Technology Center in partnership with our local high school, with the Tyler Independent School District. And it's going to allow us to work with some high school seniors in our community and have those students where they're able to take the detention officer curriculum their last semester of high school and be eligible to take the license exam upon graduation from high school. And we think that's going to help us with some of our employment issues and filling some detention officer vacancies. And we had to meet with TEA, and it took some work to get that program into the Career Technology Center. And I had a meeting with Commissioner Hester and then was able to meet with Director Beecham and some of his staff, with Ms. Grisby and Cullen. And we couldn't have done that without the support of the commission and TCOLE, and I just simply wanted to thank them for their efforts. And we have we've had a lot of students interested in the program, have about 30 kids enrolled in that at the moment. So we're cautiously optimistic, but I just wanted to offer our thank you to Director Beecham and Commissioner Hester and the folks for working with us on that.
So if others are interested, may we pass on your information?
Director Beecham and Cullen have been good about that already, so that's already happening.
So we're good at that.
Well, thank you for the great work, sir. We appreciate it. And hopefully there's somebody in the audience that may be interested in speaking with you more about that type of program.
Happy to. Several of us and some of our staff are here all week, so we're happy.
Well, you know, in law enforcement, we have a tendency to do the same thing over and over again and expect different results. So we have quite a few challenges on our hands right now, and I think in order to solve them or to address them, we're going to have to start doing some things a little bit differently. So.
Well, thank you, and we agree. Thank you.
Okay, a gift. We're going to do 2 or 3 things here at one time. We are going to be going into executive session. However, we're going to go ahead and put the QR code back up in the event.
For real this time.
Yeah, for real. And I'm going to say thank you. Okay, it is 5:52, and I am showing us back in session from executive session. We have no action to be taken from executive session, so we'll move to agenda item number 12, which is to adjourn, and do we have a motion?
I make a motion that we adjourn.
Second.
We have a motion in several seconds. All those in favor say aye. Aye. Any opposed, same sign. Motion passes, and we are adjourned.